Good afternoon, everybody. My name is Chris Justice, and I'm here today again to join you for another Q&A session on all things employment law related. So, as always, definitely get your questions in, and I'll do my best to answer as many as possible. I work out of the Toronto offices of Samfiru, Tumarkin. And usually what I do is I'll start off with a couple of topics that are coming out of the news and detail a little bit about what those topics discuss and how it relates to employment law. And then I'm going to dovetail right into some questions from the audience. So again, get those questions in and we'll go through those. But first, I wanted to start with one story that's been in the news recently, and that has to do with Chapman's Ice Cream. So the ice cream business here in the country, they had earlier actually come under a bit of backlash as a result of giving $1 raise to the employees that they had who had confirmed they were vaccinated. And so there was some backlash, particularly from the community of unvaccinated individuals. They felt as though that there was some penalty or that some sort of a punishment for not being vaccinated, and some differential treatment on the basis of someone's vaccination status. And as far as employers giving incentives or penalizing people based on, let's say, vaccination status, it's a very risky thing to do. You definitely want to make sure as an employer that you're not penalizing anyone. But even as far as giving somebody $1 raise, as was the case with Chapman's, for those who were vaccinated, and as I've mentioned, they've come under a lot of backlash for that. So that kind of got me to think about a question more generally as far as, can companies incentivize people to get vaccinated? Can companies penalize people for not getting vaccinated? What is the law really around that? And one thing that companies, including Chapman's, need to be concerned about is, for example, let's say if someone wasn't able to get vaccinated based on a disability or based on a religious exemption, and they therefore don't get that $1 raise that Chapman's was giving out. Well, you could argue then, therefore, that the policy Chapman's has discriminates against people, and in this particular case, against somebody who's got a valid human rights concern, such as medical or religion related. So in that particular context, an employer would have to be cautious about penalizing somebody, especially if they've got a justification, for example, for not getting vaccinated. And then that could open up the can of worms to a huge human rights complaint. So I think part of that is why I believe Chapman's kind of responded to the backlash and basically offered a $1 pay raise for those who I believe were not vaccinated. So there's always that concern, is why isn't someone able to do something? And are they getting penalized for not being able to do that thing? And if the reason why they can't do that thing is at all protected under human rights legislation, and you've got a company policy that says these people get this, these people get that, then again, that's where employers want to be very cautious. So if you're an employer, you definitely want to be cautious about this, as mentioned. But if you're an employee and you feel as though that there's some differential treatment, that you're somehow suffering or getting punished for not doing something that you legitimately cannot do for a reason such as a medically related one or a religiously related one, you'll want to get in touch with us, and you'll want to speak to a lawyer and get some advice as far as how you deal with that situation. So before going to your employer and maybe making a huge issue of it, or maybe saying something or doing something that you might regret later on, definitely get in touch with our offices, and then we can sort of discuss with you what the next step should be and the best approach to kind of handle that. But I'm sure that may be something that we see more of as time goes on in terms of company policies and how they apply to those who are vaccinated and how they apply to those who aren't. And so just from a more general standpoint, these are going to be issues that we're going to be focusing on a lot. as far as maybe on the face of it, the policy's not being an issue, but behind the scenes, potentially affecting people with valid human rights concerns or justifications. So stay tuned for more of that. But I just wanted to raise off the top that one story and kind of how policies can definitely affect people differently, and it may actually be bad news for the company. As far as the pandemic is concerned, another hot topic has been sort of the hybrid model of the work arrangement. So a lot of people pretty much since March of 2020 transitioned to working from home, or they transitioned to working partly from home and then partly in the office, or maybe they did entirely from home and then they came back into the office for a little bit. But we've seen now more of these hybrid models in terms of where someone's able to work. And a lot of people have come to me and have sort of said that they've been working from home for upwards of 2 years now. They didn't work from home before the pandemic, but for the last 2 years, they've been working from home, and they actually just prefer to work from home, and they can do all of their job from home, and they don't really want to ever go back into the office for whatever reason. And so a lot of people in this situation have come to me and have asked me the question as far as whether or not someone can actually do that. Can I, as an employee, tell my employer, I don't want to go back into the office. It's been shown that I can work from home. I don't think there's any reason to go into the office. And so I'd rather work from home indefinitely. A lot of people think they can do that because they've done it for the last 2 years and there's been no issue. But generally speaking, unless there's a policy that you have, and obviously in an ideal world, a written policy that actually allows for you to work from home on an indefinite basis, or somehow otherwise a term of your employment that you can work from home permanently, then you shouldn't assume as an employee that you have an automatic right to insist that your employer accommodate you in that respect. And unless you have a valid reason, and one more likely tied to a human rights concern or ground, such as maybe you've got childcare commitments that need you to be at home, or you've got some other reason, again, protected under human rights legislation, that you need to be working from home, unless that's you, then there may be a very good chance that your employer can simply call you back into the workplace, into the physical workplace, even though you've been working from home. Because if it was always the case that you worked from home before, and now you've just been working from home due to the pandemic, that's very different. And as I say, you may not have as much of a leg to stand on to demand that your employer keep you working at home. If you started working from home from the very beginning of your job through until now, and your employer is asking you to come back in or to come in the workplace at all physically, then you may actually have more of an ability to say, well, hold up a minute. I signed the contract. I've been working from home my entire time here, and this is a term of my employment. So that's a slightly bit different of a scenario, just like as if you had a contract that gave you the ability to work from home, that would be different. But in a lot of cases, your employer is generally within their rights to have you come back. And again, this is a situation where before you tell your employer you're not going back into the office, or before you tell your employer that you're going to quit if they don't keep you working from home because you think that's fair, definitely get in touch with a lawyer, get in touch with our offices. And again, much like the situation as far as policies affecting the vaccinated versus the unvaccinated, before having any major communications with your employer, you want to talk to a lawyer first so that you can kind of cross the T's, dot all the I's, and make sure every step you're taking along the way is the right one that you need to take. Because again, much like these COVID policies, we're going to be seeing a lot more issues come as a result of these hybrid working relationships, working from home, working in the office, or a combination of the two. Just one other quick point before I get into some of the questions from the audience, and this is something I've been talking about throughout really the pandemic, but actually when the vaccine policies got introduced, more specifically, is if you're an employee and you are being asked to be that you need to be vaccinated, by your company saying that you need to be vaccinated in order to keep your job, or in order to work in some capacity with that company, definitely get in touch with us. Don't assume as an employee that you are required to get vaccinated in order to keep your job. And if you lose your job as a result of not getting vaccinated, don't assume you're owed nothing. And there's a very good chance, in fact, that you'll be owed something. You'll be owed severance if you've lost your job for not getting vaccinated, or if you've been placed on an unpaid leave of absence for not getting vaccinated, which I think I see in one of the questions that we'll talk about in a minute. A lot of people have been placed on a leave of absence or a suspension, an unpaid suspension for not getting vaccinated. So the law can very easily treat that just like a termination, and that can also trigger your severance entitlements. So if you've been terminated, suspended, put on a leave of absence, laid off, whatever it is regarding not getting vaccinated or not complying with the company's policy, get in touch with us. Because if you're not going to go back or you don't want to go back, then it's completely in your interest to find out what you can potentially get on the way out. And if, as long as there's not a government mandate that applies to your particular industry that actually requires all of the employees in that industry or in your company to be vaccinated, then there's, as I say, a very high likelihood that you'll be owed severance, and something you should definitely pursue, again, if you're not going back for sure. And you don't want to have something like this wait around. You don't want to take a lot of time before you decide. It's better to at least talk to a lawyer first, understand kind of what your options are, and then at least that point you can make a fully informed decision as far as what step you take next in the future. I may touch on a bit more of some topics in the news as we go along, but I'm just going to get into some of the questions first, and then I can go back. So the first question I've got from Lisa on Facebook. Question is, my employer laid off a member of staff due to vaccination status. Should they be required to pay back pay for unvaccinated employees who are placed on a layoff? And so I just talked about this a second ago, as far as employees who are laid off or put on some sort of an unpaid leave because they won't disclose their vaccination status. They won't confirm that they've received 1 or 2 doses of the vaccine, whatever it is. If it's related at all to the COVID policy that the company has, and the company is saying that because you're not complying with something they've asked for, your payment is being stopped, you're being placed on an unpaid leave, then again, you'll want to get in touch with us. And as far as getting back pay, sort of in a sense, that is something that's achievable, because you could argue that the day they stopped paying you was the day that you were effectively terminated. And so if they stopped paying you January 1st, and it's now we're into May, as far as your question about back pay, well, if your termination arguably happened on January 1st, then you would be seeking termination pay from that date going forward. So again, if you've been someone placed on an unpaid leave for the last 5 months, then, absolutely, you could go after the company for those 5 months that have passed as far as your severance, and then some, maybe into the future, several more months, depending on various factors, like how long you've been there, and what your job was and how much you made, and whether you find a job, and kind of the likelihood of that. But yeah, as far as back pay or severance or payment of some sort, if you've stopped getting paid by your employer, that's definitely something you'll want to look into. So thanks, Lisa, for your question, because I know it affects a lot of people. I've got another question in from Simon on YouTube, who's asking if I can provide some tips on appealing a denied EI claim over a refusal to take the COVID-19 vaccine. So generally speaking, that's going to obviously be up to Service Canada. That's going to be up to that branch of the government to decide. I will say that in talking with most clients of mine who have lost their job for a refusal to get the vaccine, they are having a difficult time collecting EI. So you're definitely not alone. And I'm not at all surprised that you, or anyone for that matter, is denied their EI benefits in this type of a situation. Because as far as I understand, you would apply for your EI benefits. You would be, I guess, denied those EI benefits. And then, as you mentioned, Simon, there's a mechanism in place where you can appeal that denial. And I would imagine that the appeal would be based on the same reasons that the application was based on, as far as, I'm looking for EI benefits because I lost my job, which is obviously what has to happen in order to collect EI to begin with. But it's not as though you quit, first of all. And it's also not as though you committed some willful act of misconduct, something very extreme. Normally these would be the only two circumstances where someone would be denied EI. If they quit and it was a valid resignation, or if they, for example, were terminated because they stole or because they assaulted an employee. Again, something egregious and usually something intentional that constitutes significant misconduct. And in my personal view, I don't think that you would argue that refusal to get vaccinated would constitute that same form of misconduct that historically has been required to deny someone EI. So frankly, I think these individuals, such as yourself, Simon, should get EI. But that's the general argument you would have to make, is that sort of in a nutshell, the punishment doesn't fit the crime. If you're in an industry where there is no mandate that actually requires your employer to have all of its employees vaccinated, that's a huge part of it too. I think as much as you can rely on the actual law itself, and again, it may be better left to a lawyer, and that's something that our law firm is also helping people with, by the way, is to help out appeal denied EI claims. But yeah, I would say you definitely want to focus on the law. And if there's no mandate that requires a vaccine, then how can your refusal to get vaccinated sort of rise to the level that would be bad enough where you just simply cannot collect EI? So these are the types of arguments that generally I think should be made. Another argument you could make over an EI denial claim might be to do with human rights concerns. So if you are somebody who was denied EI, denied EI for refusing to get vaccinated, but you can't get vaccinated because your doctor suggested you not do that, or maybe you have a religious exemption, then I think that's also something that should be put in front of EI, or at least included in your appeal, because that can help justify things. Another thing someone may want to highlight in terms of possibly having a better chance of getting EI is to potentially explain that it's possible for that person to do their job from home. I think from a practical standpoint, if you can make an argument, whether it's to EI or your own employer for that matter, that you can do 100% of your job from home, and for that reason, there shouldn't be as much of an emphasis or focal point on you getting vaccinated. That's something you definitely want to highlight, as I say, whether it's to your employer or EI. So I would say for EI purposes, all you can really do is include as much context as you can, and sort of as best you can show that the reasons for the denial are, they don't line up with what was done in your case. Other than that, again, it's in EI's hands, it's in Service Canada's hands. And what I'm telling people is to simply appeal the decision as much as you can, because at some point there's going to be a final decision that needs to be made, or some sort of a hearing that gets held. And that will ultimately decide it, as far as I understand. So I don't know if there's much more that you can do in terms of that, but that's sort of the general path that I would go down. And again, Jonathan, if you need any further help or have any further questions on this type of a situation, you can definitely give our law firm a call, and we can set up a consultation to discuss further with you. But that's generally speaking, sort of the roadmap I would give to a lot of people as far as how to pursue those EI benefits. But thanks, Simon, for your question. I appreciate it. I've got another question in from Mark on Facebook. Mark's asking or stating that he has an employment contract which has a non-compete clause that prevents him from working in his profession for almost 2 years. His contract is several years old. And Mark is asking if it would still be applicable now, despite the recent changes to workers' rights. And so this is a good question, Mark. I think it's important to talk about non-compete clauses. There are a lot of contracts, whether it's nowadays or back in the days, that would have a section in the contract that talks about competition. And Mark, your contract, it seems like, talks about something that says you can't essentially compete with this business 2 years after you're done with our company. Let's say you get let go, and then you've got a contract that says after we terminate you, you can't actually compete with us. You can't work with any of our competitors for 2 years. Generally speaking, what you need to know, Mark, and what everyone needs to know is that it's going to likely be very difficult, if not impossible, for your employer to actually justify a non-competition clause. There have been recent changes in the law that have actually banned the use of non-competition clauses. There is some question as far as whether the recent ban has retroactive effect as far as affecting contracts that would have predated the changes. But I still think even if your contract is several years old, as it stood back then, it's still very difficult for a company to justify a non-competition clause. So the number one thing would be to not assume that you are prevented from working as a result of that clause. Number two would be to definitely get in touch with a lawyer in order to go through the clause itself, because I think the wording of your contract could be important. But as it comes, as far as it relates to non-competition clauses, it's usually on the employer themselves to prove why it should be justified. And because courts in this province anyways don't like things that prevent somebody from looking for work or making a living, that is why a lot of these clauses are frowned upon, especially for one that prevents you from working for 2 years. If we're looking at a clause that prevents you from working for a competitor for maybe a few months in a very specific geographic location, in a very specific context, that's a lot different than a clause that says, oh, you can't work for any competitors for 2 years. Very, very general, very broad, and highly, highly unlikely that a court is ever going to pay any attention to it whatsoever, which would be good, obviously, for you, Mark, and for others, because that'll, of course, give you an ability to go out and look for a job and not have something like that hinder you. But generally speaking, very difficult, again, for companies to prove. But you want to get in touch with us if you have some questions about non-competition clauses, so that, again, we can go through the actual contract itself and give you a more precise understanding of sort of where any risks lie, if anything, and what your next best step should be. But thanks for the question, Mark. I've got some more questions coming in. Question from Rocket on YouTube. Rocket's asking if an employer can discipline you verbally, or does it have to be in writing? I find it's easy to disagree in writing and then argue. This is a comment from Rocket. So Rocket, technically an employer can discipline you verbally, and it can also discipline you in writing. A lot of disciplinary policies start off with a verbal warning and then maybe escalate to a written warning, and then maybe another written warning, and then perhaps a suspension or a termination. But there's usually some sort of progression in there, and a lot of times it might start with a verbal. Now, having said that, Rocket, you mentioned that it's easy to disagree in writing and then argue. And that's a good point. It's easier to have things put in writing. That way, there's no ambiguity. There's no uncertainty about what the criticism was, first of all. So you'll have it clearly set out in writing. Number two, as you mentioned, you can then respond to that email or that letter in writing and dispute what you think is wrong about it, or agree with what you think is right about it. But at least you've got that record. And if your employer is unfairly disciplining you and you believe that, let's say, all of the criticisms towards you are not fair or untrue, then you're absolutely going to want to push back on that, because the employer, if they don't get any pushback, are going to assume that what they said was correct. They're going to assume that, that's now the first step in a potential case that they might be building to get rid of you later on down the line. But if you push back instantly or with the first answer, and I'm not saying be difficult for the sake of it, but if you legitimately believe these criticisms are unfair, then you definitely want to create a record. And if you can show that those criticisms are unfair, it's going to obviously be a lot harder for your employer to rely on, let's say, that first warning that they gave you a few months ago when it comes time later on if they decide to terminate. So you want to make sure you are vocal. I definitely would suggest having your employer put the criticisms in writing so that you can have a chance to fully understand it, and so there is no confusion later on. And certainly, if you disagree, then absolutely argue. And at that point, you've pretty much done all you can. If your employer is still insisting or that you're wrong, or insisting that you need to be further punished or whatever, then that might get into a bit more of a messy situation, which might be something that you should get in touch with us about, Rocket, before going further on. But yeah, it always starts with making sure everything's in writing and having that clear sort of line of communication, so that you can push back when needed, and so that they know they can't just rely on something later on that might not be actually correct whatsoever. But thanks for your question, Rocket. It's good, because disciplinary policy issues are a pretty common theme in my practice. I've got a question in from JC on YouTube. JC's asking, if your job involves travel that's usually by flight, would the new vaccine requirement trigger a constructive dismissal if the employer didn't offer alternate transportation? So yeah, as we know, there are different rules rather when it comes to vaccines in the airline industry. And if you've got a job essentially where it sort of depends on a third party, like usually the relationships between you and your employer. But if you've got an airline, maybe as a third party, or in order to do your job, you need to get access to a building that's managed or controlled by a different company. So there's just sort of this, like I say, this third party involved in the performance of your job. That can definitely complicate things. I think in terms of whether your employer should offer alternate transportation, it would depend on sort of what the cost was to them. Because normally speaking, your employer is obligated to try to accommodate you within reason in order to do your job. And I think you could definitely make a good argument that if your job required you to fly, but you could actually also do it through car, and the cost and expense of the company wasn't actually that much bigger, if at all, from the flight, then I definitely think there is a legitimate argument that could be made, where there would be some pressure put on the company to accommodate you. And if they didn't, you may actually be able to argue a constructive dismissal because you can't do your job, but you believe you can, and they're just not willing to accommodate you. It would always come down to the facts, like every case does. But I think there is sort of a line of argument, JC, there that you could make to argue a constructive dismissal for sure. But this might also be one where you want to flesh it out a bit more in detail with a lawyer through a consultation. I think I would need a little bit more information as far as the history and what's been going on before I would advise what your specific next step should be. But I think in general, if you're an employee looking for accommodation and you're suggesting something that's practical, that won't involve that much more cost, if any, on your employer, and you do want to keep your job and are interested in doing that and not having it lost because you didn't comply with the vaccine policy, then I think that's a general good starting point. And then it'll just depend on what your employer's pushback is and why they responded in that way, and whether that would ultimately be viewed as reasonable or not. But I appreciate the question, JC. It's an interesting one. There are these sort of complexities that are going to come as a result of the pandemic, and these little fine points where, because it's all unprecedented, we don't exactly know the degree to which someone's obligated to do something. But from a legal and from a logical sense, I think your question is valid, and I think there could be something there, but maybe something for us to talk about further in a consultation. Thanks though for the question though, JC. Thanks again, everyone, for getting questions in. I'll answer at least one more, and then I've got to go. But I'll start with a question from Danelda on Facebook. She's asking, or he is asking, I keep hearing the term wrongful dismissal, but I'm not sure if that applies to me. Can you explain the term more? Okay, so I'll do my best in the short amount of time, Danelda, sorry. It's a wrongful dismissal can mean a number of things. It can mean the way in which somebody's terminated is wrong. So, for example, you're paraded around the office and there's this big ordeal and you're embarrassed or humiliated. That's an extreme example of a bad faith manner in which someone's let go. So a wrongful dismissal could be the way someone's let go, or maybe the reasoning behind why someone's let go. But it could also mean that someone's let go maybe for legitimate reasons, but they're simply not, which is more often than not the case. So if you're an employee who's been given a severance package that's very low in monetary value compared to what you could get, and your employer refuses to give you what's fair and owed, that's a wrongful dismissal. If you're an employee who is discriminated against and lost your job on the basis of your skin color, that's a wrongful dismissal. And it could be they could both be involved at the same time. You could be let go for bad faith reasons, which are wrongful, and also denied a fair severance package on your way out. So in general, Danelda, that's how I would define a wrongful dismissal. And so that can really include a whole number of situations under quite a big umbrella. But if anything like that applies to you or anyone else for that matter, who's watching today or listening, definitely get in touch with a lawyer. If you feel like you've been wrongfully dismissed, that's a good enough starting point. You contact us, you give us some of the specifics, and we'll do everything we can to help you out with that dismissal. And as I say, make sure that you get what's fair and owed and coming your way. But that'll do it for my time today, everyone. I do thank you all for your questions, and I will be back, and I will answer as many questions when I get back as I can. But thanks again. We've got another session, as noted below, 1 o'clock Pacific time, Tuesday, tomorrow, with Darren Saul. So definitely tune in for that. If you have any questions, I'm sure he'll be able to help out. And until I see everyone next time, have a great rest of your week, and do take care. All the best. Bye for now.